Assalamualaikum and a very good morning and greeting to our lecturer. Today, our group from group 16 will present a case concerning contract law involving Mas Sindram Berhad with two other parties, which is Sams and Leong. So, before we start our presentation, I will introduce our group member consists of Ainina Fariha, Nur Shafika, Nur Afika Shahira, and me, Aina Shamimi.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Shafika binti Wajari. My metric number S71179. Today, I will tell you a little about the case we have chosen. Here, I am attached the case question. The case tells about the two contract agreement involve Mas Sindram Berhad. The first is land purchase agreement. Mas Sindram Berhad signed an agreement to buy 10 acres of resident land from Semi at price of 2 million, which is far below the market value. This situation arose due to financial pressure and the threat of bankruptcy experienced by Semi. However, when Semi financial situation recovered after negotiation with creditor, he felt that the decision to sell the land at the price was hasty and want to cancel the contract because the agreed price did not reflect the actual market value. The second is about the office building rental agreement. In this rental agreement, Mas Sindram Berhad rent an office building from Leong at monthly rental rate of 1,500, which reflect the market rate. The agreement provided very flexible term. Mas Sindram Berhad could occupy the premise as long as the company won with no fixed end date. However, when a more attractive rental offer emerged from another party, Leong began to consider terminate the contract on the ground that the indefinite duration might render the contract valid. In this case, the topic involved free concern, coercion, and certainty. In this case agreement, there are two issues. So, I will discuss the first issue and my friend tell the second issue. The first issue is whether the land sale agreement between Semi and Mas Sindram Berhad is legally valid and can it be cancelled on ground of duress due to financial pressure. The second slide is the law. There are two sections in the contract at 1915 for the first issue. The first is section 14, free consent. Consent is invalid if obtained through coercion, under influence, fraud, and misrepresentation, meaning that a contract is only valid if both parties give the consent volunteer. If consent is obtained through coercion or fraud, then the contract is invalid or can be voided. The second is section 15, coercion. Coercion means commit by the penal code or the unlawful detaining to detain any property with the intention of causing any person to enter into an agreement. This section talks about the situation where someone is wrongfully forced to agree to a contract. An example of case related to the issue is Pao On versus Lau Yilong, 1980. This case describes the transfer of share in a company owned by Pao On to a public company owned by the Lau family. In this case, the defendant argued that he was forced to enter into a guarantee due to financial pressure. The court held that although there was pressure, it was not unlawful, nor did it amount to coercion, as the party had time to consider the deed and act voluntarily under commercial judgment.
Thank you to the past presenter. I will continue this presentation. Me, Aina Shamimi binti Sabali, matrix number S722X6. So, next, I will present the application section for issue 1, which is whether the land sale agreement between Semi and Mas Sindram Berhad is legally valid and can it be cancelled on grounds of duress due to financial pressure. So, based on the fact, Semi claimed he agreed to sell his land to Mas Sendirian Berhad for Rm2 million, which was significantly below market value. He alleges that he did so because he was under financial pressure and feared being declared bankrupt. However, under Section 14 of the Contract Act 1950, consent is considered a free unless it is caused by coercion, undue influence, fraud, misrepresentations, or mistake. In this case, we see that there is no evidence that Mas Sendirian Berhad used any form of coercion as defined under a Section 15, which refer to unlawful treat or act prohibited by the penal code. Furthermore, there is no special relationship between the parties that would suggest undue influence. In the landmark case of Pao On versus Lau Wing Long, the court held that mere financial pressure does not amount to coercion unless it involve illegitimate pressure or leave the person with no practical choice. Therefore, Semi's financial situation alone does not invalidate his consent. Next, to conclude our analysis of the issue regarding the land sale between Semi and Mas Sendirian Berhad, based on the relevant provisions of the Contract Act 1950, particularly Section 14, it is clear that a contract is only valid if it is made with a free consent. In this case, Semi claimed that he agreed to sell the land due to a financial pressure. However, under Section 15, financial pressure does not meet the legal definition of coercion, as there is no evidence of any unlawful treat or act by Mas Sendirian Berhad. Furthermore, the principle established in the case of Pao On versus Lau Wing Long support the position that economic duress or financial pressure alone does not invalidate a contract unless there is illegitimate or unlawful pressure, which is not present here. Therefore, we can conclude that Semi's consent was given freely and the land sale contract between him and Mas Sendirian Berhad is a valid and enforceable under Malaysian contract law. That's all for me. I will pass to the next presenter.
Assalamualaikum and good day everyone. My name is Norafika Shahira binti Muhammad Zaini and my metric number is S7Y85. I will now explain the second issue and the law that applies in this case. Let's start with the issue. The issue is whether Leong can cancel the office building lease agreement with Mas STM BHD on the ground that the contract is invalid due to the unclear lease term. In other words, thus the uncertainty about how long the lease is possessed to last make the agreement void. Now moving on to the law. The relevant law here is Section 13 of the Contract Act 1915, which talk about certainty in agreement. According to Section 13, agreement the meaning of which is not certain or capable of being made certain are void. This means that if contract include unclear or vague terms and those terms cannot be made certain, then the whole contract is considered invalid. To support this, we refer to the case of Karupan Centi versus Shua Tian, decided in 1916. In this case, the court ruled that a land lease agreement which allowed the tenant to stay for as long as he liked was invalid because the lease period was too uncertain. The court clearly stated that the duration of the lease is a fundamental term. If this term is not clearly defined or cannot be determined, then the agreement is void under Section 13. And this principle is highly relevant to Leon's situation. That's all for me for the issue and the law. I will pass the presentation to the next member.
Thank you for the past presenter. Hi, Assalamualaikum. My name is Ainina Farihah binti Mazuki. My metric number S70214. So I will be explain about application and conclusion for issue number 2. I will start with application. Whether Leong can breach the office building lease agreement with Masjid Berhad on the ground that the contract is invalid due to the unclear lease term. So the answer would be yes. It is because Leong can breach the agreement with Masjid Berhad due to the uncertainty in the contract agreement because it does not state a fixed and clear period of time. This is evident by the contract agreement which states that the term of the lease are unusually flexible, giving Masjid Berhad the right to occupy the premise for as long as the company wish, an arrangement which has no definite end date. Based on Section 30, the meaning of which is not certain or capable of being made certain are void. Although Masjid Berhad may argue that they have acted in accordance with the agreement and have agreed to pay the office rent at the price fixed by Leong of 1,500, also believe that the office building lease agreement is valid. However, that opinion is still not strong enough to cover the fundamental weakness of the contract because it does not have a clear end date. So this Masjid Berhad case similar with case law of Karupan Chetty versus Sohtian 1916. According to this case law, the court decision has ruled that a land lease agreement with a term for as long as he like is invalid due to uncertainty. So the court decision confirmed that the fundamental aspect is an important term in a lease agreement. Okay, so right now I will explain about conclusion in this issue number 2. So in conclusion, whether Leong can breach the office building lease agreement with Masjid Berhad on the ground that the contract is invalid due to the unclear lease term, so the answer would be yes, according to the provision of the Contract Act 1950, specifically in Section 30, an agreement that contains fundamental aspect unclear or unenforceable is declared as void. So, support from the case of Karupan Chetty versus Sohtian 1916 also strength that Leong reason to breach this agreement. It is because the court decision which held that uncertainty in the essential fundamental aspect of the contract, one of which is the period of time, will render the contract is void. So, the office building lease agreement between Leong and Masjid Berhad can be void and unenforceable under the law. So, that is all from me for application and conclusion. Thank you. Okay, so that is all from our group for this explanation for question number 2 involving Masjid Berhad versus two other parties which is Leong and Semi. So, thank you so much.